Good morning, everyone. I think we'll make a start. You're very welcome to the publication of the independent review by Angus McCullough, KC, of PSNI conduct relating to covert measures against journalists, lawyers and others of special status between the 1st of January 2011 and the 1st of November 2024. I'm Sinead Simpson, the Chief Executive of the Policing Board, and I'll be facilitating this morning's media launch, which is also being live streamed. Just a few housekeeping arrangements to run through. There are no fire or other alarms scheduled, so please follow the directions of staff if an alarm sounds. And if I can ask you all to make sure that phones are now placed on silent. So the order for today's event is as follows. The Chief Constable will give a short introduction in a moment to the report, after which Mr. McCullough will present his report. Then Mr. McCullough will be joined by the Chief Constable, by Mukesh Sharma, the Chair of the Policing Board, and by the Board's Human Rights Advisor, John Wadham. Both the Chief Constable and the Chair will give their comments on the report's findings, and after that there will be a chance for questions and answers. So thank you for attending this morning. Can I invite Chief Constable John Boucher to say a few words? Thank you.
Thank you, Sinead. So, in June of last year, as a result of concerns raised by various bodies, including the Northern Ireland Policing Board, and following an internal PSNI report that I commissioned to examine the use of covert measures in the PSNI against journalists and lawyers, I then commissioned Angus McCullough KC to undertake an independent review into conduct by the PSNI arising from concerns raised in relation to surveillance of journalists and other special status groups. This review is entirely independent. I'll shortly invite Mr. McCullough to provide some opening remarks about his report, which I am publishing this morning. Once he's finished his remarks, I and the Chair of the Policing Board, Mukesh Sharma, and our Human Rights Legal Advisor to the Board, Mr. John Wadham, will join Mr. McCullough on the stage. I and the Chair will then provide you with our responses to the report, and then we'll be very happy to take questions. Okay. Angus.
Chief Constable, thank you. Good morning, everyone. As you've heard, my name is Angus McCullough. Thank you to the media representatives for being here and to all those who are following these proceedings online. I was appointed by the Chief Constable to conduct this independent review in June of last year. Having formally submitted my report to the Chief Constable, I am very pleased that it is being published by him now, today. This is the main report of the review, although if my first recommendation is accepted, it will not be the last. The report should now be available to download on the PSNI website, as well as on my review website. I think those in the room will have seen it. It is a long document running to some 200 pages, and I would emphasize that it is necessary for anyone wanting to have a proper understanding of my findings and the recommendations to refer to the complete report. For the purposes of today, it may be helpful to provide a brief introduction to that report. On the morning of the 31st of August 2018, 2 journalists were arrested in their homes in Northern Ireland. Their houses were searched, as were the offices of the film production company with which they were involved. Large quantities of equipment and documents were seized, and police officers undertook a surveillance operation of a person thought to be their source. The investigation was led by the Durham Constabulary, who had been brought in by PSNI, but it is clear that there was operational input from PSNI itself. Those two journalists, Barry McCaffrey and Trevor Burney, had been working on a documentary called No Stone Unturned about the Loughin Island murders, an atrocity in which 6 men were shot dead and 5 others injured in a UVF attack on a village pub in 1994. Nobody has ever been prosecuted for those murders, and the work of these journalists included investigation of allegations of state collusion. In subsequent legal proceedings, it has been determined that the search warrants and the authorization for the surveillance operation were unlawful. It also came to light that in 2013, while working on a different investigation into alleged illegal payments to a senior official within PSNI, billing data for Mr. McCaffrey's work phone had been authorized to be obtained covertly. This was admitted to have been unlawful by PSNI, although they were applying the statutory guidance that was in place at the time, which in 2015 was remedied to set out additional protections for journalist sources. There was understandable concern, and in some quarters, understandable outrage at these events. 2 journalists who had been investigating mass murder and allegations of state collusion had been arrested and subject to covert measures and surveillance of a suspected source. The warrants and authorizations under which this was done were found to have been unlawful. The concerns were not just about the implications for Mr. McCaffrey and Mr. Burney, serious though those obviously were. They were also about the chilling effect that this could have on investigative journalism in Northern Ireland. The right of freedom of expression, including the freedom for journalists and civil society to examine the actions of the state, is fundamental to democracy. It is also of vital importance that public confidence is maintained in the police and in the processes by which officers conduct covert operations and surveillance. It is clear to me that this disturbing episode has been a major cause of loss of trust in the police in this area. There are parallel concerns of similar gravity, although without such an obvious triggering event, as to whether lawyers and the rights of their clients to have privileged communications with those lawyers may have been abused in the exercise of covert measures. Respect for legal professional privilege is an aspect of the rule of law and another tenet of a free society. All that is a significant part of the background to my having been asked to conduct the independent review that has led to this report. I say at the outset that there are some cases that are under continuing consideration by the Investigatory Powers Tribunal, and those currently fall outside my remit under the terms of reference until those cases have concluded. That position has been clear from the outset. It is set out in the terms of reference. And on discussion with the advisory group, about which I will say a little more in a moment, these cases were excluded from the remit of the review under my terms, but only for so long as they are ongoing before the statutory judicial body, the Investigatory Powers Tribunal. And that is for reasons which, insofar as they are not self-evident, are explained, have been explained on the website and are now also reiterated in the report. Some relevant IPT cases have concluded over the last year and so have fallen back within my remit, and we have looked at them. One person took the decision to withdraw their IPT claim so that I could consider it within the remit of this review rather than deferring such consideration. I have followed the cases that are currently ongoing and made a proposal for them to be considered by me once the IPT proceedings have concluded. But it did not seem to me to be appropriate or in the wider public interest to delay publication of this report as soon as it could be achieved. I don't want to say much about the method and approach that we have adopted in conducting this review because it is set out in considerable detail in the report. As school children, we were often told in exams to show our working. We in this review have sought to show our working, and it is set out, as I say, in detail in the report, so that the thoroughness of the exercise and the basis, as I would suggest, for confidence that we have reached robust and reliable conclusions is apparent. Findings. What have we found? At the outset, I would highlight that in Part L of the report, I have set out and seek to address and clarify various matters which have been misunderstood or misreported in the coverage relating to the subject matter of the review or the scope of the review itself. In doing so, I fully appreciate that there are particular challenges in reporting these matters arising from the difficulty in accessing any, let alone complete and verifiably reliable information. So in putting forward that part of the report, I make no criticism of the journalists and their work in this area. But I hope that section is of assistance to reporters who I know will be doing their best to provide accurate and balanced coverage alongside my detailed findings. It really is necessary to read the full report for a proper understanding. But for now, the following headlines, and they are no more than headlines, in relation to matters within my current remit under the terms of reference, so as I've made clear, excluding particular cases that are ongoing before the Investigatory Powers Tribunal, I highlight the following. First, assertions in some quarters that PSNI have been conducting systemic wholesale surveillance of journalists and lawyers are misplaced. Our detailed searches provide no support for concerns at that scale. Second, the corollary of that is that where covert measures are being deployed in relation to the groups under review, they are largely being lawfully applied, properly applying principles of necessity and proportionality in recognition of the sensitivities in these particular areas. The report includes a detailed breakdown of the applications, authorizations, and investigations in each category to help understanding of the different ways in which the powers may be exercised and why in most cases I have reached the view that they are being appropriately exercised. Third, this is complicated. Any proper understanding of what PSNI has and has not been doing in relation to areas within my remit requires specificity in the identification of the particular covert powers involved and understanding the nature of those, the purpose of the application of any such power in any particular case, the risks of obtaining sensitive information collaterally, and the safeguards put in place. All this can quite easily be lost in any discussion. Furthermore, it is complicated by the fact that the legislative regime has changed significantly during the period under review, and there have been repeated changes to the relevant statutory codes of practice which the police and other law enforcement agencies are required to apply. At the risk of what may be an unduly lengthy report, I have done my best to unpick those various aspects with the huge assistance of my two assistants in order to facilitate an understanding that is not always easy to extract from the headlines or the press reports. Fourth, by far the most widely used covert measure is obtaining communications data. It is important to appreciate that the obtaining of communications data does not involve accessing the content of any communications and technically does not constitute surveillance, but it is a significant intrusive power. This is explained in more detail in the report, but it is essentially records of numbers connected with times and durations of a call or text, and it may be associated with subscriber information. As I say, it is an intrusive measure, but far less intrusive than some other covert powers. Of course, it must be exercised lawfully, which in essence, in this context, means only when necessary and proportionate and with proper safeguards. So fifth, and turning to the specific headlines of the findings, and I advance these in particular categories. Firstly, communications data, and I made clear what communications data does and doesn't involve, relating to journalists. The report identifies some specific cases in which I consider the covert measures are likely to have been authorized unlawfully. These involve 7 journalists in cases with authorizations to obtain communications data to identify a journalistic source. All these cases predate 2015 and were in a period in which it is now recognized that the statutory code of practice in place was deficient. Those journalists, apart from one who has sadly since died, have been notified. But I should make clear, these are in addition to the case of Mr. McCaffrey that I have previously referred to, also predating 2013 in relation to the communications data obtained in his case. Next, communications data for lawyers. I have identified one case, but involving more than one lawyer, where the consideration of legal professional privilege was, in my view, inadequate to a degree that I doubt the legality of the authorization in that case. Those lawyers have been notified by me with, I should say, the approval of the Chief Constable. Next, directed surveillance applications. Now, directed surveillance is, of course, an intrusive power. By definition, it is not a power that is exercised in an individual's home to conduct surveillance in an individual's home or car, and the various other protections. But broadly speaking, that more intrusive surveillance is labeled intrusive surveillance and is distinct from directed surveillance. I've found no instances of intrusive surveillance within my remit in the time period. Apart from the directed surveillance authorization seeking to identify Mr. Burney and Mr. McCaffrey's source, we have identified 2 others relating to journalists. One I consider to have been entirely lawful. The other relates to the well-known investigative journalist Donal McIntyre and is considered in detail in the report. And it will be seen that I have considerable concerns about the process adopted in that case. Next, directed surveillance applications involving lawyers. I have identified 2 separate DSAs, as I will use the abbreviation, involving the same lawyer, both of which I consider likely to have been unlawful for different reasons, as explained in the report. That lawyer has been notified. In addition, I am aware of an issue in relation to the conduct of surveillance in courthouses,